Is this working? Can you hear me? Great. You said it, timely. I mean, I can't think of a better time to have this panel here at the 92nd Street Y. You know, every June we're used to having the Supreme Court come out with these major decisions, and we've already seen that this year, of course, momentous decisions last year, which is the focus of much of Michael's book as well. But on top of that, as we're figuring out and thinking through how the Supreme Court is also going to be dealing with all these big election law issues over the next year, we've got one of the most surreal weeks in American history when a former president is indicted by the federal government for the first time. There's so many big questions at play here right now. How did the Supreme Court come to play such a large role in our politics? How will this court and its rulings affect the 2024 election? And how is the court going to change the fabric of the country for years to come? And we've got a perfect panel to deal with it. The man of the hour here, Michael Waldman, president of the Brennan Center and author of the new book, The Supermajority, How the Supreme Court Divided America. Wilford Codrington III, associate professor of law, dean's research scholar at Brooklyn Law School. He's also a Brennan Center fellow and the author of The People's Constitution, The Definitive History of the Amendments to the Constitution, which I just learned there had never before been a legal book written about the amendments to the Constitution, which kind of blew my mind. Congratulations for being the first. And finally, Christina Rodriguez, the late Homer Surbeck Professor of Law at Yale Law School and co-chair of the Presidential Commission on the Supreme Court of the United States. And we are going to get to the Supreme Court decisions both last year and this year, but I have to begin with you guys, given the news of the last several days. And Michael, let me start with you first. What do you make of the indictment? What do you make of those who say it is simply improper and selective prosecution for someone who is appointed ultimately through the President of the United States to be bringing a prosecution like this? And then finally, how the Supreme Court, what kind of role they might be playing as this case works its way through the courts? And I want all of you to address those questions, but why don't you start off?
Well, first of all, let me start by thanking you, George, for doing this, for being such a great teacher to all of us as we try to understand every day and every week what's going on in our country. And we're grateful to you and to our hosts for doing this. This is a big day. It's unprecedented. I start out somewhat queasy with the idea of a former president being indicted. I think there's many reasons why this has not happened before and why we've held back. You can understand all the reasons why it could be destabilizing, why there could be retaliation. I also, before knowing what we know, was questioning the whole issue of the classified documents, because there's a lot of overclassification of documents and that sort of thing. Having said that, reading the indictment, and as Chris Christie said, if half of it is, as former Attorney General Barr said, if half of it is true, it's quite extraordinary, and I don't think that they had a choice but to bring charges. These are serious charges. If you remember, during the 2020 election, over and over again, Donald Trump said, oh, we're going to go to the Supreme Court, they're going to save me. I don't know that he's saying that right now about this. Even though the court has been quite conservative, it has held back from helping him in his somewhat tortured interpretations of the law and the Constitution. I don't know there's a deep constitutional question here because he's a former president, but I don't know that they're necessarily in mind to rescue him either.
Yeah, would you agree with that, Walter? Because it does seem like in the past the court has shown great deference to a sitting president, but as Michael said, this court, in some of the motions that made it, they kind of dealt with them with great dispatch and just didn't seem to think that there were big constitutional questions at issue.
Right, I think that's right. He's a private citizen, right? He has no rights that you or I don't have. He has some special privileges. He's an ex-president, so therefore we have to make some accommodations with Secret Service when he's sort of fingerprinted and things like that, but there's nothing special about him right now. I do want to urge some caution, though. One thing I am concerned about, just think about the impeachments. These were really big deals, right? That we get a president impeached twice. Now we have a president who is now indicted twice. Maybe he will be indicted more. But what's going to happen after this? I'm curious. This is going to be a jury trial. So one thing I am concerned about is what happens in the end, and is this just made out to be some partisan affair in the end if he is actually acquitted? But this is historic, of course, and I think it does call for us to, as a country, to rethink this whole sort of institution of the presidency and the sort of division of powers and other things about our government right now. And I think that's what makes this book special, because it talks about all of these things to some extent or another at a time where we really need to be having these conversations.
That's an excellent point, and we'll definitely come back to it. Before we get to that, Christina, I do want to finish this round with you, because it seems to me, at least, right now, that Donald Trump's legal strategy is actually a political strategy. Delay the case as long as he possibly can. Hope that it goes over past the election, count on the fact he's hoping that either he wins or another Republican wins. And either the Republican pardons him, or if he wins, he pardons himself. That's a question that's never really been looked at before. But is it constitutional for a president to pardon himself?
I don't think anyone's ever definitively answered that question, in part because it's entirely unprecedented. I think the more likely eventuality is that he or some of the Republican wins and they dismiss the case. And so we don't have to get to that question, leaving it unanswered for future generations. But there is an opinion from the Office of Legal Counsel and the Department of Justice from back in the 1970s that says that it's not permissible for a president to pardon themselves. And that stems from the view that you can't be a judge in your own case, that a pardon is an extension of mercy to is implied someone else, and so it doesn't fit within the framework of what a pardon was understood to be, to have someone pardon themselves. So we'll see if that is eventually what happens. I think if he's convicted, wins election, becomes president either from prison or on probation.
He can be convicted and get elected.
Yes, he can. And then pardons himself. Will a court actually countermand that pardon? I don't think any court wants to touch that question. And so it really, in the end, might be the political question that you set out.
And we'll see if we get to that. Many more twists and turns in the election. Michael, let's talk a little bit about your book. One of the big points you make in the book is that with last year's decisions, crystallized last June, of course, the overturning of Roe v. Wade, the big Second Amendment decision, you say the court compressed decades of social change into 3 days. Explain what you meant by that.
Well, the court is a singular institution that we have 9 unelected government officials serving for a lifetime making such big decisions. And we give them this power. The Constitution, the part of the Constitution that deals with the Supreme Court is only 1/10 that of the parts dealing with the presidency and the Congress. It has accumulated all this power because we want to believe it's a court, we want to believe it's above politics, that it is in some way ultimately following the Constitution. At the end of last term, the first full term of this 6-vote supermajority of conservatives moving in lockstep, the cases made massive social change, pushed things way to the right. As you said, Dobbs overturned Roe v. Wade, which had been the guarantee of reproductive rights in the federal Constitution for half a century, and did it in a way that put at risk all the other privacy rights in the Constitution as well. The day before was by far the most sweeping Second Amendment ruling in the country's history. Didn't get as much attention, partly because of what came right after, which said basically that you could not consider public safety when considering gun regulation, only what history and tradition tells us, meaning what they did back in the 1700s. And the last day was the opening of a really significant long-term effort to curb the power of regulatory agencies to protect the environment. These are, by many measures, legislative questions. They were crammed into these 3 decisions, and we will see more things like that going forward.
Sweeping decisions, no question about it, but not really a surprise. I mean, this is exactly what Donald Trump promised as he was appointing Supreme Court justices. It's basically what the justices, if you look back at their history, they were acting in keeping with what they had done. And, to the victors go the spoils, right?
Well, Trump in 2016 said, if you vote for me, my justices will get appointed and they will automatically overturn Roe v. Wade. It's not a surprise that presidents get to make these appointments and they're going to have some political valence. Right now, though, what we have is something we haven't had really in a long time, or maybe in the country's history, which is a faction of a faction has captured this institution. You don't have judges or justices kind of wandering and evolving and changing their views. They're moving more or less in lockstep, at least so far. And that is pretty significant and pretty.
You know, you just made me think of, I interviewed Stephen Breyer about his final book before he left the court last year, where he was really taking great pains to say that the justices on the Supreme Court do not act politically. They do it just by looking at the law. And Christina, I pressed him very hard on that at the time. And I think often he tried to do that, but I think it's hard to look at some of these decisions and say, oh, there were no politics at play here.
The image that evokes to me is one that Michael describes in his book, where with Justice Breyer holding his head in his hands. And I think that image of him reacting to whatever's happening on the current court, I think is inconsistent with the view that politics are not driving the court, and that there's not something deeply political at stake. And I think justices like Breyer and Justice Kagan makes comments to this effect too, need to believe that they're making decisions based on the law and their good faith interpretation of the law. But the questions that come before the court are increasingly political in nature. And the polarized state of our political institutions means that more and more policy questions come before the courts as a whole, and that leads them to wade into debates that produce this kind of social outcry. And often their outcomes reflect partisan divisions, even if they don't think self-consciously, I'm deciding this question for the Democrats or for the Republicans, but it often turns out that way.
Wilfred, we've seen a case this term that seems somewhat political, but maybe in the opposite direction. This voting rights case out of Alabama, where Chief Justice Roberts and Justice Kavanaugh joined those who were appointed by the Democrats and basically upheld the Voting Rights Act in a minority district in Alabama. I think it shocked a lot of Supreme Court watchers. Did it shock you? What do you make of it?
I would be lying if I said I wasn't shocked by this opinion, and so would anybody else who tells you. It was a huge opinion. Allen versus Milligan coming out of Alabama, and it had to do with redistricting. So basically, Alabama has about 28% of its population are black citizens, and if you think about I'm not going to explain the sort of details of it, but under the Voting Rights Act, Section 2, which has national coverage, basically Alabama should have 2 majority black districts. In January of last year, what happened was the Supreme Court stopped a lower court decision saying that, you should have 2 black districts and punted. So last Thursday is when the world sort of shook, and we got the decision that Chief Justice Roberts, who himself had been going after the Voting Rights Act since he was an itty-bitty lawyer in the Department of Justice, he was the one who actually wrote the opinion saying that Section 2 was constitutional and that Alabama had applied it correctly. So I think that was a shock. I think we should celebrate that as the victory that it is, but we should also be cautious that this is just staunching the bleeding. This is not some sort of new right. It's not an extension of the Voting Rights Act. And in fact, we know from the dissents that we have naysayers who are still coming at the Voting Rights Act. So there are a lot of questions about the Voting Rights Act, which I think have been teed up by this decision. So we should keep our eye on the ball there.
Christina, we have a little precedent for this with Chief Justice Roberts. Of course, he upheld Obamacare, drew a lot of fire from his conservative allies. I was a little bit more surprised that Kavanaugh joined in, and of course, he made the difference. How do you assess that?
I think in a lot of his opinions, Justice Kavanaugh is showing either a pragmatic side or an interest in conciliation or consensus building. And I think some of that could be his temperament. Some of it could be that he doesn't have the same view about the speed with which the law should change that the other conservative justices in the majority do. But it's really an issue by issue question, because he was part of the majority in Dobbs, and which overruled Roe versus Wade. His view was that we needed to return the issue to the states and the political process. So he tried to soften the blow, and so he's trying to play this, I think, establishmentarian role in a way and keep the court supposedly out of political controversy. It doesn't always work out.
You want to weigh in on this?
Yeah, I think that we know that Chief Justice Roberts is in some ways an institutionalist, and that he does think about the credibility of the court. He has worked to steer it to the right, but slowly and cautiously. We saw that in the Affordable Care Act case where he switched his vote. And Kavanaugh is looking at the world, as is Roberts, at a time when the credibility of the court, its approval rating, has collapsed to by far the lowest level in polls ever recorded. They would have to be blind to the world around them not to realize that was going on. So we can say, oh, that's political for them to be responding this way. There's kind of a blurred line.
Capital P sense, right? I mean,
yeah. Well, the court does not have intrinsic power. It has to find a way to get the public, the country, to accept what it's doing, and especially as they're making big moves. And going back to the last year, if you think about the three big cases, guns, abortion, and the interests of the fossil fuel industry, that sounds like a political caucus and a party convention. So they have to be aware that to a large part of the country, there's been a real turning against them in the last year or two.
and of course, one of the things that's hitting the credibility of the court, Wilford, let me bring this to you. We've had all these headlines about Justice Thomas in the last year, these gifts he had taken from big political contributors, not reporting the income of his wife over several years, but basically everybody kind of just throws up their hands and says there's nothing we can do. The Supreme Court doesn't live by any ethics regulations. It does seem that the Chief Justice is sort of wrestling with what to do, but his hands are really tied, aren't they?
Yeah, I mean, there are some things that a Chief Justice can do to sort of sway opinion on the court. Chief Justices often, they are the sort of the spokesperson of the court in addition to being the administrator of the court. But, there is not a lot to do. There is a statute that forbids any sort of conflicts of interest and bribery, so they're bound by that. But at this point, justices act as their own individual agents, and you can tell from what Clarence Thomas said that, I got advice from somebody else on the judiciary about how I should be filing my disclosure forms, right? So, they are independent in a way. They work as a body, but I think Chief Justice Roberts is really feeling the heat right now. I'm concerned that there's not going to be the responsiveness. It seems to me Clarence Thomas in particular is sort of living his best life, and living his best life not on a judge's salary. So I don't know what happens, but I feel like at least Roberts, and maybe to some extent Kavanaugh, in addition to the other liberals on the court, they at least understand that the institution of the court is at stake here.
And Christina, you co-chaired the Presidential Commission on the Supreme Court, which had to look at all of these questions about possible reforms of the Supreme Court. Talk about that experience a little bit. And it seemed like the final outcome of your commission was predetermined. That it was not something that was going to lead to a consensus on where the court should go. But talk about your experience, what you learned.
So as a presidential commission, we had no power, as Michael well knows, and we were asked not to make recommendations, but instead to assess the major proposals for reform that are out in the debate. Despite the fact that it was a bipartisan commission and there was disagreement about just about everything, including how to tell the story of history, of the election of 1800, of the New Deal, there was some agreement on a few issues, or at least consensus. The first was on the importance of ethics reform, that there is no excuse for the Supreme Court not to have a code of ethics, and for that code to be transparent, and for people to understand why justices do and do not recuse themselves from certain cases. The second was that of all of the reforms that are being debated, there is widespread interest in limiting the terms of the justices. That life tenure is not an institution that makes sense, not just because lifespans are growing and many justices live into their 90s, but because no one should have that much power for such a long period of time over the policymaking and interpretation of the Constitution of the United States, and that it's important, if not necessary, for the personnel of the Supreme Court to reflect the outcomes of elections. And so the idea that one president, say Trump, could get 3 nominations in 4 years, and another president, Jimmy Carter, could get 0 nominations in 4 years does not make sense and leads to the kind of misalignment that I think is driving Michael's critique between what the people want and what the court is
Sealand
doing.
in what, 18 years seemed to make the
18
most
years.
sense.
Yeah, and that would lead to each president getting 2 nominations, provided the Senate cooperates. The Senate has to cooperate under the existing framework, but that's the idea.
Well, this made me think, though, Michael, of the, now it's coming up more often, this idea of changing the Constitution so that a popular vote would determine who was the president of the United States. These kinds of reforms may make sense in the abstract. Hard to see any universe where they get through Congress right now.
Well, the popular vote, though, is one way of looking at the gap that has grown between the Supreme Court and the country, in that one party, the Democrats, have won the popular vote in 7 of the last 8 presidential elections. And that's actually the longest winning streak in American history for one party. But the other party's presidents appointed 6 of the 9 justices. In a sense, the country is moving in one direction and the court is moving in another direction. A lot of this goes to the question of whether people are willing to seek change, whether people are willing to see institutions as representing kind of increasingly entrenched minority factions, and ultimately whether to do something about it. Now, Wilfred, in his studies of the constitutional amendments, will tell us that it always seems impossible to pass constitutional amendments. It's so hard, you need all these state legislatures, and then about every 50 years or so, things pile up and get really bad, and then a burst of amendments happen. And they've often been to expand democracy.
Well, let me bring that to you, because I think a lot of people look at what the court did last year and say, and I do want to remind everybody to, if you have any questions, please write them down, and we'll get to them in just a couple of minutes. They look at this and say that despite the popular vote over the last several elections, we actually have minority rule in this country right now. Does that lead to the kind of crisis that could fuel a movement for constitutional amendments?
Yeah, I think so. And so thanks, Michael, for the plug. But it's true. What we've seen in history is that we've amended the Constitution in these spurts, in these waves. And at each juncture, we kind of thought like the country was going to fall apart. And so when we're talking about minoritarian rule, it makes me think about the Civil War period. Right, we were being held captured to a hostile region of the country. Clearly, did not have the support of the majority.
Everybody.
Sorry,
people watching on TV won't realize that there's a very excited fly who cares a lot about the Swedes.
Go ahead.
So it's just that we've seen this. We've been held hostage by a minoritarian faction before. That was the South in the Civil War era. We've been held hostage by a corrupt faction of the country before. That was the Senate in the Progressive era. We've been held hostage by the South in the 1960s. And we've amended the Constitution at these critical times to make sure that it reflected that we are going to be a multiracial democracy that's going to hold our government accountable, that we're actually going to be a government of, by, and for the people.
Do you see a plausible path for any constitutional amendments right now?
You know, at the moment, no. What I do think, though, is that, nobody else saw the plausible paths before either. Right, so we have a really strict partisan alignment right now, where Republicans are really deep red and Democrats are mostly really deep blue. But but there have been realignments in the past, right? So the Republican Party, as we know it today, was not the Republican Party that we had in the '60s. That Republican Party was passing civil rights legislation. The Democratic Party that we know today is not the Democratic Party of the Old South of the 1860s. And so something else can catalyze some sort of rejiggering of the political parties. I think that what happens is that we get something that's just so cataclysmic. We get, a civil war, a Dred Scott decision. We get total corruption in the Senate. We have marchers in the South being sprayed by hoses and attacked by dogs. And maybe we get an insurrection on the Capitol and it wakes people up to say, hey, the Constitution that these guys wrote in the 1700s is not doing the job today.
It does seem, Christina, like in the wake of the Dobbs decision, that did spark a kind of political backlash. And do you see that affecting future decisions of the court on abortion?
It certainly had an electoral consequence in the midterm elections. That much seems clear. I could see it affecting the way that Justice Kavanaugh decides some questions that come before the court, if the questions are in the form of, can one state use its authority to limit its citizens to travel to another state to procure an abortion? If those kinds of questions come before the court, I see possibilities for compromise. But and if there's I think the ultimate goal of the pro-life movement, which is a case that goes to the court on the question of whether there's such a thing as fetal personhood under the Constitution. I don't see the court reaching out that far. That might be a naive statement that will come back to haunt me and others in the future, but the experience of the reaction to Dobbs might inform some people's judgment in that eventuality, if that comes to pass. But I also think that this court, and Michael's book brings this out quite clearly, is on its path to realize the goals of the conservative legal movement across many domains of constitutional decision-making and regulation. And that is its objective. In the Dobbs opinion, Justice Alito says it doesn't matter what the public thinks. And there are a number of them who believe that because they think that what they're doing is interpreting the Constitution. And so I wouldn't put that much faith in this group as a whole to listen to public reaction.
Do you want to say it?
Well, I was going to say the other thing that shields them from the public in their own mind, and they do say, oh, it would be crass for us to care about public opinion, is now they are articulating the view that they are acting under originalism, that the only legitimate way to interpret the Constitution is to ask what it meant to the people who ratified it. That's really new. I mean, it really wasn't until last June that was in 2 cases at a time, the way the Supreme Court ruled. It's frankly reactionary. It literally says we have to turn back the clock to whatever the social views of property-owning white men of the 1700s and 1800s were. It's a really radical change and, in my view, an absurd way to run a modern, growing, changing country. And it has only begun. And the notion of history is the history that's being relied on is often wrong or caricatured. As in the book, I say it resembles the medieval time theme restaurant, in its costumes. It's not really the actual history, but even if it was, it's not a way our country has ever made constitutional rulings before, when courts kind of knew their place but also understood the country was changing and they needed to allow it to change.
Wilford brought up January 6th. Former President Trump is also facing this investigation in Georgia about trying to overturn the election there. And of course, the special counsel is also looking at his efforts in Washington to overturn the election. Again, how do you expect the Supreme Court to look at, in the Georgia case, you might see Trump make a motion to say this should not be in a state court. This has to be done in federal court. They have no legitimacy to do this right now. Who knows what the special counsel is going to do on whether or not he charges Trump for January 6th. But you also have this movement inside the House now among Democrats to say that Trump violated the 14th Amendment by fomenting an insurrection. How would you imagine the court would look at that question and the questions raised in Fulton County?
Those are kind of bread and butter criminal procedure questions. Defendants move to change their case, to remove their case from state court to federal court. You get a different jury.
Right.
You get the suburbs of Atlanta and not just the city of Atlanta, if that were to happen. That kind of thing, one could imagine, could go up to the Supreme Court. And there is a lot of precedent that ought to govern that kind of thing. Again, so far, I think these justices have viewed in the past, in the last few years, have viewed Trump and his antics and his travails as a distraction, potentially, from their bigger project, which they've all been engaged in and working on for years and decades. And so they have not shown an appetite to kind of break the rules for him, but of course that could change. I mean, one thing we see with the lower courts, and this is one of the reasons a lot of people are concerned about this judge in Florida being reassigned this case, is that we now see that the lower court judges who think they want to get a promotion to a court of appeals really have to toe the line on certain MAGA goals and atmospherics, or they will never get that promotion. So there's a degree to which the politicization we see in the Supreme Court is even more extreme in the lower courts, where people aren't paying so much attention.
And Christine, it's going to be fascinating to see how this judge down in Florida deals with this case, given how often and how decisively she was overturned in her initial rulings that were so favorable to former President Trump. There's some question now that she should recuse herself or she should be forced to recuse. Is that realistic in any way?
I doubt it's realistic as a matter of what she will decide to do, but legal ethics experts do point to a statute that would require her recusal if she could not be perceived to adjudicate or preside over the case in an impartial fashion. And I think it's fair to say that the public would be justified in not trusting her to be impartial, given the way she bent over backwards in the lawsuit that Trump brought to try to get the documents returned to him from the DOJ, in which the 11th Circuit basically said that she'd gone so far over the line that she had to be rebuked. There are also procedures for other judges within the 11th Circuit to require her to be recused or to shift the case over to someone else. I think that would be an extraordinary move, is my guess. And so the prosecution should be prepared to be trying the case before her. But so much of this is novel and unusual that I will not be surprised if a recusal is forthcoming in coming days.
I would be pretty surprised. Well, Rolf, how different is it now that everything is seen, every decision made at the lower courts, at the Supreme Court is seen through a purely political lens? It feels to me like the gulf is far greater than anything we've seen, maybe going back to the Civil War. You've studied all of these movements. What do you make of that?
Yeah, I mean, there's always some extent to which courts are seen as partisan, but I think that there's just these points of flare-ups where the court just makes these really, really bad decisions and there's no other way to think about them. And so Michael's book highlights this nicely. When you have the Dred Scott decision, the court really thought it was going to resolve the issue of slavery. And so it said, we're going to solve this problem once and for all, basically. That was the sort of undertone there, because Congress wasn't doing anything about it. Or with Lochner decision, the court was stepping in it, really, right? The court was saying, well, these laws that are upholding, protecting wage and labor and other things that were not really governed, we're going to create this whole sort of economic due process, substantive due process right to say that you have this right to your property and this liberty interest, and the court said this is the way we're going to go with this. And I think when the court really gets in those sort of big decisions, it seems as overly political. I think Dobbs is that decision here. There may be others, but I think Dobbs is that decision, and so it's really hard to not think about that as politics instead of trying to think about a way that fits in sort of law as we think about it.
And part of what makes it feel different is that the parties have sorted now so that the Democrats are to the left and the Republicans are to the right. Before there was more of a jumble, but these things were very political. Dred Scott led to the rise of Abraham Lincoln to the presidency because, among other things, it basically said the platform of this new Republican Party is unconstitutional. The response was so intense, so explosive, that it led to Lincoln being elected and ultimately the Civil War and the end of slavery. In the early 20th century, in the period Wilford was describing, when the justices of that time saw their role as being to stop government from dealing with industrialization and protecting workers' rights and women, it was massively political in ways I hadn't even realized. Teddy Roosevelt, in his 1912 presidential campaign, this fabled campaign where he ran against his hand-chosen successor, Woodrow Wilson was the Democrat, Eugene Debs was the fourth candidate. Teddy Roosevelt's big issue was the Supreme Court and the Lochner case and these reactionary rulings. And it was a huge, huge political debate, well before his cousin Franklin finally took on the court. And even the Warren Court, so as you know, the Brennan Center is named after Justice William Brennan, one of the great leaders of the Warren Court. It was not seen as partisan, and it was the only time that the court was ahead of the country in advancing rights and equality, but it was very controversial by the end, And we are still living in the backlash. So much of the modern conservative movement, so much of the modern Republican Party grew out of a response to some of the rulings by the Supreme Court in the 60s and especially the 1970s.
Which would lead you to think in the long term, Christina, that the only answer to a political court is more politics. Maybe different politics, but more politics.
I don't disagree with that in the sense that the Supreme Court has long been and will for perhaps ever be a political institution that decides questions that are not just legal, they also have a political underpinning. But that's why reforms to the court, like term limits, that would better align what the justices, the composition of the justices with the outcome of the political process, would make the court a more functional part of the system, where even if we retain strong forms of judicial review, that review is more likely to be attuned to the general sense of the public. And that's why institutional reform is important, not because we need to return to a view of the court as an apolitical body that decides questions of law, but because we need it to be a better cog in the democratic machine.
And that actually gets to one of the questions we got from the audience, and Wilfred, I'll start this one with you. Why should the Supreme Court care about public opinion? What incentive do they have to care?
Well, the Supreme Court has no real power without the public behind it, right? The Supreme Court doesn't have an army like the president. The Supreme Court doesn't print money or pay for anything. All it has, as Alexander Hamilton said, was judgment, right? And so the Supreme Court has to be at least cognizant of what the public believes about it, and it's particularly on really explosive issues, right? I think there's sort of like a run-of-the-mill case where the court can just chug along and think about it and do most of its work, and I think that is actually, I don't want to sort of blow this up to be everything the court does is political. The most of the work that the court does is not. A lot of the work that the court does is decided in sort of lopsided majorities and not just based on the supermajority that we have now. But there are big decisions that we think about as being these political decisions as really impactful in terms of policy that need to be with the political branches. And when they're not, and when the court steps into that, then the court really needs to justify it. It's a decision to do so.
You know, Michael, I don't know if you can even answer this question, but how much do you think the justices even talk about this among themselves? Can they?
One thing we have heard is that a lot of the communications within the court has broken down, that they don't really talk about these things when they're off the record. You know, they need this kind of monastic silence to give us the sense that they're reaching wise decisions. But last
We're
year...
at a time where the dissents are getting sharper and more personal.
Dissents are getting sharper and more personal. They've started to attack each other in speeches. Clarence Thomas last year gave a speech saying, well, this was a great place to work until John Roberts became Chief Justice, basically. We learned, of course, about Ginny Thomas's role leading up to the insurrection. So many very noisy, clamorous things happening just as they were getting ready to issue these big rulings. And Elena Kagan has said, you know, even if we talk about kids and baseball, we're not talking about these big ideas off the record. It seems as though there's a time of great distrust. In an earlier era, someone likened the Supreme Court to 9 scorpions in a bottle. Now the scorpions are kind of crawling all over the table, you know.
Christina, we have another question from the audience asking, you teach, of course, at Yale, has the Supreme Court's break with precedent and stare decisis affected how law students are taught now?
I think for some people, the last term made teaching constitutional law difficult, and I do teach constitutional law to first-year students. I have always taught the course as a course in political history, political theory, and in eras. The court plays a role in the larger system of government and in our social and political life that is distinct depending on the politics of the day. And so now the court is playing the role of the conservative supermajority that is invalidating a lot of old enactments from the 1960s and 70s to be more in line with conservative policy principles, and it is defending these long sought after views of the meaning of certain rights provisions of the Constitution, the Second Amendment, the 14th Amendment. And that is of a piece with the way the court behaved in other eras when it was reacting to the world around it and reflecting the views of the people who'd been appointed to the court. So if you think of the court that way, it's actually not hard to teach it, but it does make it very different from any other course you would teach in law school, where the precedents that you teach are supposed to be reliable and not susceptible to this ongoing change. But I think that's what constitutional law is. It's a fight over what kind of country we have and what values we hold, and the court plays a central role in that.
Let me ask a follow-up on that to Wilfred. I mean, I know you're not teaching this semester, but do you find that your students are reflecting the political divide, or you teach at Brooklyn Law School, is there a more homogeneous political community there? How does the diversity of political views come into play in choosing the law students' classes, and how does it affect the classroom?
I would say, I mean, we're in Brooklyn. We are, so my students reflect what Brooklyn does, I think, largely. But we do definitely have diversity there. I just want to sort of pick up on what Christina said. I try to emphasize to my students, I also teach 1L constitutional law, which is very different than your other common law courses. So students kind of come in scared, not sure what they want, but they know that the Supreme Court is why they went to law school, or a lot of them at least. And I try to tell them, I'm going to try to help you think through these problems. I'm going to help teach you the history of this. I'm going to help teach you these methodologies that these jurists are employing, or say they're employing at least. And then I'm going to let you do the work, because the doctrine is the doctrine. And the doctrine is also going to be changing, as we're seeing. And so what I can do is just give you the tools to think through these problems, to critique this, and to educate other people so you can make the difference.
We just got another question, Michael, and you write about this a bit in your book as well. What are your thoughts about the leak of the Dobbs decision?
It was shocking, at the very least, to see it in cold type. There had been other leaks before. The Dred Scott decision leaked, for example. It actually leaked to the incoming president, James Buchanan. He wanted them to make that ruling, and he got up and gave his inaugural address, and he said, well, there's going to be a big Supreme Court ruling. None of us know what it's going to say. Let's all agree that whatever it says, we'll go along with it, right? and the next day, the newspaper said, well, we know what that means. There have been other leaks. When this happened, I'll admit, my first instinct was to assume it was a liberal. That was somebody who was appalled by the ruling, maybe one of the staff or the clerks or something. And maybe these are just my own biases, but the more I looked at it, there is a recent pattern and practice of leaks on the conservative side. When John Roberts switched his vote from overturning Obamacare to finding a way to uphold it, that leaked. And there was a big push to try to get him, don't go wobbly, John Roberts.
Lock him in. Yeah.
Lock him in. There was something similar in a case called Bostock a few years ago, an LGBTQ rights case, where about a month before the ruling, all of a sudden there were articles saying, Neil Gorsuch, don't fall for Lena Kagan's wily arguments. And that was exactly what was happening. And in fact, he did rule in the pro-gay rights direction there. A week before the Politico article, the Wall Street Journal editorial page basically had the same thing. And then a week after the Politico article, there was another Politico article that said, well, the 5 votes are still holding. Well, they didn't get that from Sonia Sotomayor, presumably. So who knows? They did not do a very energetic job of trying to find out.
It didn't seem like they really wanted to find who did this leak.
As you know, politicians can fulminate about leaks and demand action, and half the time that means they leaked it. Maybe Supreme Court justices are in the same way.
Although, at this point, I think we're likely never to know. It was interesting that in the Politico article that did this, there was actually a national security reporter who co-bylined the article, not their normal Supreme Court reporter. And it does seem like that's where the information came from. This reporter was not on the typical beat. It's impossible to know how that person got it, but it was fascinating stuff. Christine, let me put you on the spot here. One of the decisions we're still waiting for this term is the decision about affirmative action. A, what do you expect, given the fact that we were surprised last week on the Voting Rights Act? And B, how do you expect that it's going to affect the composition of your classes in the law schools?
I think most everyone expects that the court is going to cut back on affirmative action in some way, and the question is how. They may limit it to invalidating the particular affirmative action policies of the 2 schools that are before them, Harvard and University of North Carolina, or they could go further and say that any consideration of race in admissions policies is a violation of the Equal Protection Clause, which could have much broader implications for recruiting strategies and other ways that schools go about trying to enroll underrepresented groups and create a diverse class. I think that in about 2 weeks, if they're not already working on this, general counsel's offices of universities are going to be figuring out what can be accomplished during the next admissions cycle. And I think that probably the best thing that people could do now is to study what the University of California system has done, because their race preferences or race consciousness has been illegal as a matter of a voter referendum for decades, and the numbers have gone up and down. And different schools in that system have used different strategies for enrolling diverse classes, including focusing on socioeconomic status, geography, other things that are not perfect substitutes for race itself, but that can help create a class that's diverse across a lot of different dimensions.
Well, and that's what I was wondering about, and maybe this is completely wrong, but when I look at the issue, I wonder if no matter what the Supreme Court decides, is it really going to have an earth-shaking effect? Colleges, universities, law schools, medical schools are going to need diverse student bodies no matter what. They'll find a way to do it, right?
I mean, I hope so. I'll just add another sort of policy model that we usually don't look to Texas for policy, but what we might start doing is also looking to states like Texas who do a talented 10th program where they basically take the top 10% of students and they give them admission to the University of Texas system. Notably, that does build on residential segregation. So in some way, we are using race as a proxy, and so the idea of saying that this is race blind is sort of laughable. But will universities suffer? I think some will. I think generally we think about these big flagship state schools in these cases, and they tend to have more resources. They have more staff to look at these applications individually. They can put more resources towards recruiting and sort of outreach and things like that. I think the smaller ones that sort of are running and operating on a sort of tuition-based budget model, where do they get the resources and the ability to deal with these questions? I don't know. And so we'll have to see, and I, like Christina, hope that general counsels have been working on this, certainly know that they will be.
I was only going to say that I think there will be drop-offs in enrollments, particularly of Black and Latino students at a number of places around the country. That's what happened in California in the beginning, and there was evidence to that effect in the Michigan case 20 years ago when the court heard this, that had an impact on the justices who thought that that would be a disastrous consequence. But in the intervening years, other strategies have emerged to try to ameliorate those effects, and those are the strategies that universities are going to be required to turn to, I think.
And that kind of evidence had a big impact on Justice Sandra Day O'Connor, who you clerked for, who was the last politician to serve on the Supreme Court and who thought about these things. I think these universities have baked this into their thinking and planning for a while. I think they know what's coming. And the question, I think, for them, but for all of us is, there's a lot of affirmative action that's left. Legacies, athletes, all the other ways that there's tilting of the scales and money and building a gym, and one of the questions is, will there be political pressure on these universities to take on some of those advantages now that if the court blocks some of these?
We're just about out of time, Michael. I know you're going to sign books when we're done here, but when you look at the Supreme Court right now, and you had a pretty dire analysis in the book, what gives you hope?
What gives me hope is that people are paying attention, that people are responding, that people are seeing the nature of the institution, and that liberals, among others, are no longer bedazzled by the glow of the Warren Court half a century later. I think there's tremendous enthusiasm for some of the reforms that Christina mentioned. Term limits, for example, are very popular across the political spectrum. It reflects the insight that George Washington had, that he limited himself to 2 terms. I think the more the public gets involved, the more there's organizing and talking and treating this properly as a political fight, the more confidence I have.
What gives me some hope is the mainstreaming of some of these ideas about reforming the court and rethinking the court's role. The other thing that we haven't mentioned today, but that has been implicit in some of the comments, is the awakening by Democrats that judges really matter, and that the Biden administration has been, I think, extremely successful in populating the lower courts with new and diverse nominees, professionally diverse and diverse in other ways, and that the courts are worth fighting for and fighting over at the same time that we think about how to reorient their power. And so that, to me, is suggestive of a future of potentially more equilibrium.
I'll say what gives me hope is the next generations. I think the next generation, we have to rely on that. And without them, I would have zero hope. But I think the next generations really see the urgency of the questions that are coming before the court. I think if it weren't for the sort of younger generations, we wouldn't be thinking about the EPA decision the way that we think about it. I think if it wasn't for the next generation, Joe Biden wouldn't have made that slip and said that he supports gay marriage before Barack Obama did, and the Supreme Court may not have gone the way that it did. I think so. My hope is that, in addition to the fact that these are way more publicized, that sort of publicity is reaching this generation of people who care about it and know that they have to be the ones to carry this country forward.
Thank you all for a very stimulating discussion. Thank you all for those great questions. Michael's going to sign the book. Have a great night, everyone.